Whistleblowing and non-disclosure agreements. Can you still blow the whistle after you've signed a non-disclosure agreement? And if so, how? Been a lot in the news lately about non-disclosure agreements. Omarosa Manigault-Newman, former presidential advisor as well as former reality star, has written a book, is giving interviews, and the Trump administration, the Trump campaign are trying to silence her by enforcing a non-disclosure agreement. Stormy Daniels' litigation about non-disclosure agreement in a settlement agreement, and a number of other government. There are reports that the government is currently routinely using non-disclosure agreements with federal employees to try and keep them from criticizing the administration as current employees or once they've left the government. The thing is, as you look at those reports, news reports almost always talk about the fact that legal experts say those non-disclosure agreements are probably illegal, that there are a number of laws, but most recently the Whistleblower Enhanced Protection Act of 2012, passed unanimously by Congress, makes it illegal for the government to use a policy, use a provision in an employment contract to keep government employees or former government employees from taking otherwise legal actions to report fraud, especially report it to Congress, but also report it to the inspectors general or engage in other whistleblowing activity. And it's not just government employees. There are laws that protect the rights of private individuals to report fraud to the government. The courts view it as very high public policy that we want people to be able to report fraud, and therefore courts will generally hold as invalid provisions in employment contracts or severance agreements that limit an employee's ability to report fraud to the government. HIPAA, the health privacy law, very important, very strict law. It has an exception that allows people with access to healthcare information to share it with their lawyers carefully, so that their lawyers can help them report fraud to the government. That tells you how significant this public policy is. The Securities and Exchange Commission has recently been fining companies for including in severance agreements or employment contracts provisions that limit an employee's ability to report fraud to the government. And importantly, the SEC has fined companies even when it acknowledged, so the company argued and the SEC acknowledged that the company never tried to actually enforce these agreements. And so why would that be? Why is that so important? And the answer is because the question of ultimate legality or enforceability isn't really the key question. The key question is, what is the objective the company is trying to accomplish, and do the agreements meet that objective? And as a number of defense lawyers have acknowledged when talking about these things, they don't have to be enforceable to be effective. They don't have to be legal to work. That they work if they keep a whistleblower from speaking out. They really work if they keep a whistleblower from even talking to a lawyer about whether they're enforceable. And the way they work is if they make a potential whistleblower question whether it is worth it to speak up, whether it's worth it in light of the cost of hiring a lawyer to defend them if the company did try and enforce it. The fact that if there were a proceeding that were made public, they would be outed as a whistleblower, and that could have real negative consequences on their job. The fact that a lot of these agreements include provisions that talk about clawing back your severance payment. I've even seen some that talk about questioning whether they're going to take away part of your 401k, which no way can I imagine that being legal. But when you look at it, and you as someone who is thinking of blowing the whistle, these can be really scary. And it is that fear factor, that deterrent effect, that a lot of times the companies are looking for. And so the question is, for you, if you're thinking of blowing the whistle, but you've got one of these non-disclosure agreements, or maybe your company you're leaving on your terms or involuntarily, and they're asking you to sign one, what do you do? And The short answer is hire a lawyer to help you, advise you. First and foremost, what you really don't want to do is, having watched a video like this or read something in the paper, say, these aren't enforceable, I'm just going to do my thing. Because the fact is, even the laws that say that they are generally not enforceable, it's for certain aspects. And so you want to talk to a lawyer and get a sense of what kind of whistleblowing you want to do, what information you have, and the right way to approach it to protect yourself. Not just to protect yourself ultimately down the road, meaning you would win in the court, but to protect yourself up front, to minimize the chance that the company is going to take action against you, and that if they do, the burden it's going to place on you. And actually, there's more to it than that. If you, depending on how you do it, if you're thoughtful about it and cautious about it, you can actually take steps that make it so the company faces some of those practical burdens. The company's not going to want publicity. They're often not going to want their executives to have to be deposed. There are a number of things. And so depending on how the structure goes, it's not just you who bears the burden if you have to contest the validity of one of these things. And that's something else that you want to talk to a lawyer about, because with all of these things, so for instance, blowing the whistle to report fraud, blowing the whistle to the government, sharing information with the government, highly protected. There are lots of policies, laws that are going to support you in doing that, and the company is going to have a hard time really challenging that. But blowing the whistle, sharing information with the press, there are also protections, but they're different, and you need to be more careful. Talking to other people, even if it's for good reasons, and trying to help public safety or things like that. Public safety policy is going to be supportive, but not as supportive. And again, you need to be careful. You need to be aware that the company is going to try and accuse you of stealing trade secrets, of using it for your own benefit. And you want to avoid situations that look like that. I should go back. One of the other highly protected ones, and this goes with government, is reporting to members of Congress. And that is a little different type of whistleblowing. Doesn't fall under the False Claims Act, but that is one of the things that can be very effective and is highly protected. But again, you want to be cautious about how you do it. You also really would like to have a lawyer help you, because any information you share, including with the government, if you share attorney-client privileged information, the company's attorney-client privileged information, that could be problematic. And so these are all things that you want to think about if you're thinking about blowing the whistle, even after you've signed a non-disclosure agreement, a confidentiality agreement, or if you're being asked to sign one. So this has been an overview of the issues involved with non-disclosure agreements, confidentiality agreements, and blowing the whistle. Each situation is different, and if you are thinking of blowing the whistle and have a non-disclosure agreement or are being asked to sign one, and you would like to get legal advice specific to your situation, give me a call. I'd be happy to talk to you, free, confidential, talk about your situation.